Right, so well, thank you for coming. And I'm going to begin the lecture with a confession, which is that in 2005 I came across this individual, who I found extremely intriguing. And sightings of him or her were relatively rare in those days, but only made studying that person all the more interesting. Would this person become more or less popular, more or less visible as time went on? And my interest certainly did not flag, as this individual's appearances did indeed become increasingly common. In fact, quite the reverse. The intrigue deepened, for some began to claim that these sightings may not have been of one individual at all, but a number of slightly different individuals, all laying claim to be the same person. And others held out that there were many such individuals who were actually identical, who might even make up a majority of the population. So conflicting were the sightings of this individual that I've been moved to write a study recently of someone who has miraculously, I think, become both more and less elusive as time has passed. And so my confession is that I have for a decade now been an average consumer groupie. And in particular, as the title of this lecture suggests, I've been particularly interested in charting his or her increasingly uncertain presence in European trademark law. So I'm here tonight to talk to you about this elusive yet ubiquitous individual. And I thought I'd begin the lecture, by looking at the origins of the average consumer and its relationship to trademark protection, then the uncertain position of the average consumer in European trademark law, then challenges to the idea of the average consumer, and finally the future of the average consumer in European trademark law. And I'd just say that I've just got an article that's come out in the most recent Intellectual Property Quarterly, which covers some of the area covered by this talk. And what I'm going to do now is concentrate sort of on ideas and themes, but if you're sort of interested in the case law and further reading, then I suggest you look at the article. Okay, so the first thing I want to talk about is the average consumer and his or her entry into trademark law. So the average consumer was imported by the Court of Justice from consumer protection laws into trademark cases shortly after the implementation of the Trademarks Directive. So in the early case of Lloyd's, which concerned the grounds for a finding of a likelihood of confusion, the court held that for the purposes of assessing confusion, account must be taken of the perceptions of the average consumer of the category of products concerned who is deemed to be reasonably well informed and reasonably observant and circumspect, as I say there. So there are two then key characteristics of the average consumer in trademark law, which are identified in this quote. He or she is assumed to be both rational, and he or she is also assumed to be informed. In other words, it seems to me that the assumption is that given the correct information, the average consumer will make a rational choice. In fact, though, the earliest origins of the average consumer, like that of the directive itself, are to be found in neoclassical economic theory. And that's understandable given the extent to which neoclassical economic theory held sway over both European governments and inevitably the EU during the past few decades. So according to this neoclassical model, while consumers have heterogeneous tastes, nonetheless it's possible to posit the existence of one utility-maximizing individual consumer whose choices coincide with all the consumers for a particular product. And this consumer has come to be known as a representative or the average consumer. Furthermore, it's also assumed that for this individual to make these utility-maximizing choices, i.e. those that are most conducive to an efficient functioning of the free market, he or she must have access to sufficient reliable information. And this latter belief is, of course, reflected in the Trademark Directive, for example, in the assumption that if consumers understand a sign as a badge of origin, it should be registered, or that, conversely, misleading or deceptive marks should not be registered. And the belief that there is a single representative consumer has further, of course, practical appeal because it enables judges who adopt this model to predict and indeed to make assumptions about aggregate consumer choice without the need for very expensive opinion polls and a collection of other evidence. Now, once embedded in European trademark law, a succession of Court of Justice cases have, of course, fleshed out the bare bones of the average consumer. For instance, we're told that he or she will pay more attention when buying expensive items than when purchasing ordinary household goods, that he or she is assumed to see different sorts of signs differently, or he or she may be less likely to see a shape or single letter as distinctive without having seen it been used on the market. Furthermore, when assessing distinctiveness, the court will assume that the average consumer will see only the sign and not surrounding matter within which it might be used, and will not break the sign down into its constituent parts. And in cases of conflict, the court will not assume that the average consumer will compare the marks side by side. Furthermore, the court will scrutinize both the circumstances in which the average consumer might perceive the sign, and it will also pay strict attention to the characteristics of the average consumer for those particular goods or services. And I think both of these points are illustrated by Mr. Justice Arnold's decision in the recent case of Enterprise Holdings and Eurocar, which I have a picture of. And so in this case, Mr. Justice Arnold suggested that as a general rule, the average consumer normally consists of people with a spectrum of attributes such as gender, age, ethnicity, and social group. However, he added that if there is evidence that the trademark is more likely to have acquired distinctiveness amongst one demographic segment of the relevant class of persons than another, it is proper to take into account. Now, Enterprise Holdings concern the infringement of a community trademark consisting on the left, as you see, of the letter E for car rentals, and the defendant's trademark, which you see on the right, was actually a moving E. So if you went onto the website, the E would move. In this case, Mr. Justice Arnold held that the average consumer, who he did indeed decide might vary in, quote, gender, age, social grouping, ethnicity, and residence, would display varying levels of attention. So here's a picture. He or she, he thought, might not always display the same level of attention throughout their interaction with the rental companies. So some might pay close attention to what they're doing when they actually book the car on the internet, but they might pay much less attention when they come to pick the car up, when he thought they might be stressed, in a hurry, or relatively inattentive. And I think that's interesting because I'm going to say later that I think that while you think you may be being incredibly perspicacious when you're booking things on the internet, in fact, the internet have ways of making you think, as it were. So I don't think we can assume that is necessarily a good example of the average consumer. There's another interesting case of Solvo Volvo, which is in my article, but I won't discuss now. So I go on from that to say that basically, over the years then, the courts have gradually refined the attributes of the average consumer. Then, more recently, in Google France and Louis Vuitton in 2010, the courts came up with another average consumer, and this was the average internet user. And it was this particular individual who the court held might be confused by the use of a trademark or a keyword in internet and a keyword in internet advertising. Now, the question of whether the average internet user is indeed a different average consumer from the one we've been accustomed to, and if so, whether there might be others whose characteristics are dependent upon the particular channels through which he or she purchases goods or services, I'm going to raise later in the lecture. Right, so I'm now going to go on to ask the next question, which is really, what is the position of the average consumer in European trademark law at the moment? And I'm going to suggest that at the moment it's quite uncertain. So from early cases, the Court of Justice and national courts have been fairly consistent in suggesting that in cases which concern the distinctiveness of a mark, it is appropriate to consider empirical evidence to ascertain the views of the average consumer. So, for example, in windsurfing, which concern the registration of geographical signs. And I think, so in windsurfing, which concerned the registration of a geographical sign, the Court of Justice suggested that the registering authority might, quote, make an overall assessment of the evidence, including the extent of use and the market share of the mark, and even opinion polls, although the conclusion they said should not be based on any predetermined percentages, as to whether or not the mark was distinctive and should be registered. Then more recently, in Borco, the Court of Justice confirmed that it was also appropriate to employ empirical evidence to determine the distinctiveness of a sign, in this case, a single Greek letter for beer, when it had not been used on the market. The Court of Justice then took the view that the OHM, in this case, had been wrong to conclude that the sign was not distinctive without seeking empirical evidence of the views of the average consumer. In other words, the OHIM said, well, it's just a letter, one letter. We can take a view that it's not going to be, because the average consumer is hypothetical, we can take a view that it's not going to be distinctive. In fact, the Court of Justice said it may prove more difficult to assess the distinctiveness of signs which have not been used, but that it was wrong of the OHIM to rely on what it termed, quote, conjecture or mere doubts, close quote. They said it was necessary to carry out an investigation based on the facts. So there seems to be then this very consistent view that in assessing distinctiveness, you can look at evidence, empirical evidence. Where the confusion really is over the ascertaining the views of the average consumer in cases involving conflicts between marks, and in particular, the question of how you assess the extent of confusion. And in recent cases, I have suggested courts have been caught between treating the average consumer as a so-called legal construct, in other words, a hypothetical individual whose views the court can make up its own mind about, and the need to seek empirical evidence in order to ascertain how many consumers might be confused. And it was in the very long and complicated case of Interflora and Marks and Spencer's that much of this confusion manifested itself. And so what I'm going to do is go through that case in order to demonstrate where that confusion lies. So you're probably aware that this case concerned an allegation by Interflora that Marks and Spencer had infringed its trademark under Article 5.1a of the Trademark Directive through its use of Interflora as a Google keyword. And a major issue, not the only issue, but a major issue, was whether the reasonably well-informed internet user would understand that Marks and Spencer's was not part of the Interflora network. And following from this, how the views of the average internet user were to be ascertained. In particular, the question arose of whether Interflora would be allowed to adduce evidence gleaned from customer surveys at trial. And it's possible to see Lord Justice Lewison's pre-trial decision on the inadmissibility of survey evidence as firmly endorsing the classic view that the average consumer is a legal construct. So the question raised was whether surveys undertaken by Interflora would enable the court to determine whether the average consumer, or in this case the average internet user, might be confused by Marks and Spencer's keyword use, since if they were, the costs of the surveys would be justified. In making this assessment, Lord Justice Lewison stated that identifying the average consumer is, quote, not a question of counting heads. Even if the court were to conclude through the use of a survey, quote, that most internet users would have grasped that Marks and Spencer's was independent of Interflora, but some would not, the court would not be, quote, any closer to identifying the average consumer, since in effect the average consumer is, quote, a hypothetical legal construct. So Lord Justice Lewison actually said that. He then suggested that surveys might have some use in identifying the shopping habits, or whether a trademark has acquired distinctiveness with average consumers, but not whether those consumers would actually be confused, or how many consumers would be confused. And he concluded that, quote, in my judgment, the results thrown up by search engines on the internet fall within the general description of ordinary consumer circumstances in relation to which the judge can make up his or her own mind without the need for either expert evidence or the evidence of consumers. Now, at trial, Mr. Justice Arnold did indeed admit considerable scientific and survey evidence from Interflora on the extent to which Internet users from 2008 to the time of trial were able to differentiate between the natural results of an Internet search and paid advertisements. He repeated Lord Justice Lewison's view that the average consumer is a legal construct, but Mr. Justice Arnold also made clear that in his view, numbers were not entirely irrelevant either when ascertaining whether or not the average consumer is confused. This divergence from what might be termed the classic view of the average consumer arose when Marks and Spencer suggested that there is a, quote, single meaning rule in European trademark law. In other words, the use of a sign is deemed to convey a single meaning in law, so the law would assume that the sign is conveyed a single meaning, even if it in fact was understood by different people in different ways in the real world. Mr. Justice Arnold disagreed. He said there was no single meaning rule, either in relation to the average consumer or the average Internet user. Indeed, instead, it was possible to conclude that the average consumer might be confused, even if only a minority of consumers were likely to be confused, as long as it was a significant minority. And he went on to hold that Marks and Spencer's had infringed Interflora's mark, and significantly that this was so, even though he said not all, and possibly not even most, but a significant proportion of consumers would be confused. Marks and Spencer's appealed, and the Court of Appeal overruled Mr. Justice Arnold on a number of points, but not, I think, on his approach to the average consumer. So Lord Justice Kitchen agreed with Arnold not only that the average consumer is essentially a legal construct, but also that it is possible to find infringement even if only a minority of consumers are confused. I mean, in my view, that's impossible, but that's what Lord Justice Kitchen said. On the one hand, he held that the average consumer test is not a statistical one, and that in determining the views of the average consumer, the court must, quote, exercise its own judgment. However, on the other hand, he also took the view that at times empirical evidence might be useful in determining the views of the relevant average consumer, and he found authority for this in the Court of Justice using such evidence in cases relating to distinctiveness. And according to Kitchen, Lord Justice Kitchen, since the distinctiveness of a trademark may determine whether there has been confusion, it would be logical to suppose that the court should have regard to the effect of the allegedly infringing sign not on all consumers, but that proportion of consumers who find the registered mark particularly distinctive. And from that it followed that it was sufficient for a finding of infringement if a significant number of these relevant class of consumers were to be confused, even if a majority of consumers were not. So basically, he repeated what Mr. Justice Arnold said. So successive judgments in the Interflora dispute raise a crucial question of whether the assumption that it is only necessary for a substantial number of average consumers to be confused, even if it's not a majority, is compatible with seeing the average consumer as a legal, that is, a hypothetical construct. But I want to suggest that the answer to this question presupposes another, which is, does the average consumer actually exist? And I would also suggest that the evidence is by no means conclusive on that score. So the next bit is I'm going to look to the challenges to the idea of the average consumer. So after the financial crash of 2008, one might be forgiven for questioning whether neoclassical economics, with its emphasis on self-regulating markets, really had all the answers. And to question the neoclassical economic model is, of course, to question the very existence of the hypothetical average utility-maximizing average consumer. However, the fact is that there was another approach, economics approach, which had been gaining ground and indeed had become, in the mainstream, had achieved mainstream status long before the 2008 crash, and that is actually behavioral economics. And I'm going to focus here on behavioral economics precisely because it has been particularly influential with brand developers and marketeers, and so therefore, it seems to me, should be of particular interest to those who are concerned with trademarks. So, by contrast to neoclassical economics, the conclusion of behavioral economics are heavily dependent upon empirical studies. So they do look at empirical studies of actual consumer behavior. And they posit a direct challenge to neoclassical economics belief in the rational nature of the average consumer. So as was put by one of its most prominent advocates, Dan Ariely, standard economics assume that we are rational, that we know all the pertinent information about our decisions, that we can calculate the value of the different options we face, and that we are cognitively unhindered in weighing the ramifications of each potential choice. The result is that we are presumed to be making logical and sensible decisions. However, he takes a contrasting view, which I've got here. He says we are far less rational in our decision-making than standard economic theory assumes. He says, though, our irrational behaviors are neither random nor senseless. They are systematic and predictable. So I think that's interesting. Then they are irrational, but they're also predictable. If they weren't predictable, then there's not much that marketeers or brand developers could do with behavioral economics. And this is just an interesting one, because this is one of the iconic images of the 2008 crash, which suggested to many people that consumer behavior is not necessarily rational. And this is Northern Rock Bank, which their rumors went out that the Northern Rock Bank was going to collapse because it didn't have enough money. So everyone who had money in the Northern Rock Bank queued to take out their money, thereby ensuring that the Northern Rock Bank would have collapsed if the government hadn't come in and saved it. So that's one of the kind of obvious examples of that view. However, I mean, beyond that, there is indeed considerable research which supports the view that even with access to reliable information, and I'm not sure whether that information was reliable or not, consumer behavior will not necessarily accord with economic modeling, which assumes its rationality. Consumers have been described as having bounded rationality, which means that they do not necessarily behave in the utility maximizing way assumed by neoclassical economists. For example, in predicting how consumers will respond to information, it is necessary to take account of presentation. So some have argued that in relation to advertising, it would be wrong to assume that the way an advert is framed would have no effect on consumer choice, even though the information content remains constant. And here's an example. Which would you choose? The 19% lean or the 10% fat? I think most people apparently would choose the 10% fat one rather than the 90% lean, even though, as obviously they mean exactly the same thing. Another one that I think is very interesting. So this is another one. Which would you choose here? 33% off or 33% more? Apparently most people, would choose 33% more because they think they're getting something for nothing, even though apparently it's better if you choose 33% off. So that's another framing. And then this one, which is actually a real one, was The Economist. So The Economist had an advert, I don't know if it's legible there, which says that for $59 you can get an online subscription, and for $125 you can get a print and web subscription. And apparently huge numbers of people opted for the $59 economics online subscription, which didn't actually that was not a good option for The Economist. They then changed it to Economist subscription to just the internet, a print subscription for $125, and a print and web subscription for $125. And more people went for the print and web subscription because they thought they were getting something for nothing. So, that is another example, and apparently a real-life example of how you can frame advertisements. So, Needless to say, it seems to me if we accept the behavioral economist's approach, it has considerable implications for assessing confusion from the point of view of the average consumer. In particular, so much in behavioral economics, its assumptions question the simple link between information and rational behavior, because here you're getting all the information and yet they can direct you to make a particular choice, which I think is quite interesting. So numerous other reasons have been suggested for why consumer choice is not simply a rational response to objective information. Those which are perhaps most relevant to the role of trademarks and branding include the lack of time to process the information, lack of practical alternatives, perhaps because they are too expensive, and a tendency to, quote, anchor assessments around initial judgments, effectively discounting the value of experience and subsequent knowledge. And of course, this latter point undermines very much the major justification for trademark protection, which has been proffered by those who adhere to the law and economics orthodoxy, because from their point of view, trademarks earn their right to legal protection through their role in reducing customer search costs and ensuring the goods bearing the registered mark exhibit a consistent quality over time. But if in fact customers make their choices on their initial impressions, then that would seem to undermine that very much. Others have pointed out to the fact that a surfeit of information of goods and services might lead consumers to restrict their choices to brands rather than making a rational choice. So they might say, God, there's so many things to choose from, I'm going to just choose this brand name that I've heard of, which again is good for brands, but it's not necessarily rational in terms of what might be best for that particular consumer. Which again, as I said, undermines the relationship of consumers to trademarks as being some sort of a rational relationship. Another example of why trademarks might be less important in consumer choices would have us assume, is that consumers appear to change their decision-making strategies in response to the context of choices they make and also the complexity of their choices. So another famous example is this, which camera would you choose? Apparently most people looking at that would choose, which one? They go for the middle one, just because a cheaper one, we don't want the cheapest one. A more expensive one, we don't want the more expensive one. Isn't it nice to just have one that's kind of in the middle? So apparently most people will go for the middle one, which is interesting when you think about, comparative advertising, right? Because here it has nothing to do with the comparative aspects of these, except for the fact that you have a real cheap one and you have a real expensive one. And then people go for the one in the middle. And then finally, another thing they talk about is the complexity of choice. So when you have multi-dimensional goods, such as, for example, a motor car, as one behavioral economist said, any ordinary car has a series of at least partially incommensurable characteristics like design, size, color, speed, acceleration, technical reliability, or safety properties, to name just some. Now, each of these characteristics provides a qualitatively different dimension along which the convenience of any given car might be judged. And so we can add to that, can't we, the trademark or the brand as being another of those characteristics, and which again would only be one factor, we suppose, on which choice will be based. And we might conclude from this that a consumer's choice to opt for one product or service over another might have a number of explanations apart from the confusing similarity of the marks which they carry. So if consumer choice is determined by the manner in which that choice is framed, then it seems to me a very small leap to the conclusion that consumers will foreground different considerations when making decisions on online shopping environment rather than in a traditional store, because isn't this all about framing the choice differently? And it is here, it seems to me, that perhaps unwittingly the Court of Justice and other courts have doffed their hats to behavioral economics when identifying a different average internet user, although probably they're not aware that they did. The problem is, of course, that they continue to assume that this is a rational individual who will make choices based on the objective information which is presented on internet shopping sites. And perhaps they're right, because research does appear to show that consumers believe they have access to more reliable information when buying products on the internet. But by the same token, It also follows that it is possible for internet suppliers to exploit this trust by framing information in a way that will maximize the likelihood that consumers will opt for one product over another. And so it's well known that online retailers will regularly deploy the knowledge that they have about a consumer, which is either specific to that particular consumer or more generally applies to the typical consumer of the product concerns, in what has been described as a filtering recommendation approach. And a very excellent example of this is actually a case, and it's Cosmetic Warriors versus Amazon, that came before the courts in 2014. And I have a very fuzzy picture of it, but I don't think you can see, but I couldn't find a better one. So in this case, the claimant sold cosmetics and toiletries under the trademark Lush, but it did not sell these products on Amazon. And if a consumer typed Lush into its search engine, he or she would have indeed been told that there was, quote, no results found. However, if that same consumer then went on to purchase goods which were similar to those supplied by the claimant, then the next time that consumer typed in Lush, he or she would get a recommendation for these same goods rather than being told that there were no results found. Now, according to the judge, Mr. John Baldwin, quote, Amazon has built up and uses a behavior-based search tool to identify an association between a particular search word and specific products. So he was aware that Amazon had actually developed a behavior-based tool. According to the judge, the average consumer, he said, would understand, quote, there are no results found, means Amazon does not supply Lush products. However, this same consumer, he said, may not understand Amazon does not supply Lush products if, subsequent to typing in Lush, other similar products are recommended. And so he concluded that by designing its search engine in this way, Amazon had in fact infringed the claimant's mark. Now, in Cosmetic Warriors, the court rejected the defendant's claim, Amazon's claim, that consumers would have the wit to understand that the proffered products did not originate from the claimant, and that to decide otherwise, quote, and I think this is interesting, would not allow fair access to technological development. Instead, the court accepted the claimant's argument that the consumer would not have the wit to understand the difference between what they were looking for and what they were offered. But it seems to me notable that while both sides of the dispute were ready to accept that methods of retailing online, which were specifically based on behavioral research, might raise particular and novel issues regarding consumer behavior, not encountered in traditional retailing, no one thought it necessary to actually adduce evidence of what those differences might be. So they said, yes, this is a behavioral tool, but nobody thought to say, well, what is the effects of using it? In fact, there was no empirical, so it seemed to me, so here then, the difference certainly lay in the way the information was being manipulated by the internet retailer in order to achieve particular consumer choice, but nobody thought it necessary to find out what those methods were. And so then let's go on to the last part of my talk, which is, what is the future of the average consumer in European trademark law? And I suggested that the average consumer is under attack on two fronts. First, the certainties of neoclassical economics, which gave rise to the rational consumer, have been challenged by other ways of understanding consumer behavior. And I've concentrated on behavioral economics. And the second is, of course, that recent case law have suggested that the average consumer is both a legal construct, but that he or she is also deemed to be numerically measurable. Indeed, the most recent, seems to me, Interflora decision by the Court of Appeal, which I've talked about here, does not make the path forward any clearer, because the court seems to be saying that it is not necessary for judges to look for evidence of what the average consumer might think in infringement cases, except when the court decides that it is. So should the courts then jettison the notion of the average consumer and learn the lessons of behavioral economics? Well, I think that is a problem, because the court might attempt to understand how the relevant consumer will react in a particular trademark dispute by drawing on the plethora of empirical research on consumer behavior, which is fundamental to behavioral economics and marketing. However, that approach has its limits. Because it is empirical, it's not clear that every study of behavioral research, or that any study of behavioral research, will fit the facts of any particular trademark dispute. So in that case, it might be difficult to generalize the results of one behavioral economic model to the particular circumstances of the case at hand. Would an alternative then be to jettison the notion of the average consumer as a hypothetical legal construct and instead look at the empirical evidence which might be available in any particular case? And in order to judge the efficacy of such an approach, it might be worth considering the example of the tort of passing off, where the use of such evidence has traditionally been allowed. In passing off, the tort, as we might know, I don't know how many of you know about passing off. Have you looked at it? Yeah. So that it's proved if a substantial proportion of actual or potential customers for the product or services have been deceived. So the court here is not dealing with a hypothetical average consumer, or was put by Lewis in Interflora, the average consumer in trademark infringement is conceptually different from the substantial proportion of the public test applied in passing off. However, although he says it's different, in fact, the approach taken in passing off seems to me remarkably similar to the approach taken in trademark cases. First of all, if you look at passing off cases, almost all the evidence which is actually adduced is adduced not about whether customers are confused, but rather whether the mark or get-up at issue has goodwill. That approach can be justified because, of course, if you can show a mark has lots of goodwill, then it's more likely that consumers will be confused. But it's still asking the same question that you ask in trademark questions when you adduce empirical evidence. That is the mark distinctive, rather than how many customers are going to be confused. Secondly, although, yes, it's clear that because you're looking at the number of consumers or customers that might be confused, it's okay to adduce evidence of customer confusion in passing off cases. The courts have traditionally been extremely reluctant to admit surveys which make this claim. So they will have frequently found such surveys to be unreliable, perhaps because an insufficient number of consumers were polled or leading questions were asked. And the real value test, which Lord Justice Lewison looks at in Interflora, applies as much to passing off as it does to trademark cases. Furthermore, despite the apparent difference in approach between passing off and registered trademark law to assessing confusion, there's actually no necessity to assess such evidence in passing off cases. And in fact, in the vast majority of cases, nobody presents any evidence of anything, really. And it's left to the judge to make up his or her own view as to whether the defendant is making a misrepresentation calculated to deceive. And this was, in a very early case in Sporting and Gamage, the court said that is exactly the House of Lords said that this is exactly what the judge should do. So, according to Lord Parker, he said there can be no doubt that in a passing off action, the question whether the matter complained of is calculated to deceive is a matter for the judge who, quote, must not surrender his own independent judgment to any witness whatsoever. In other words, judge, you make up your own mind. And a funny case, an interesting case on this point is ZTV and ZBox, which was last year, where the court was asked to decide whether a majority of customers for ZTV, which was an Indian language cable television channel, would be confused with the defendant's television information app, ZBox. The claimant said, well, of course we should be able to submit survey evidence because we're dealing with a particular group of people, that is British Asian people, who are not, are a specific part of the population. And they said that the misrepresentation would be occurring, quote, among a people and culture with whom the judge may be unfamiliar. Now, in the High Court, the judge, Mr. Justice Burst, refused, and the Court of Appeal agreed. In the Court of Appeal, Lord Justice Floyd says that judges in passing off cases are familiar with taking into account any relevant characteristics of the purchasing public and making allowances for it. He said there is nothing in this case which is likely to be unfamiliar or not readily understandable to a child judge. And it seems to me then that this is exactly the same approach that a court may take in a trademark cases if they're dealing with a hypothetical average consumer as a legal construct. So, just then, to make a final point, I've looked at the two alternative approaches. I've suggested that behavioral economics might provide useful insights about how consumers might relate to trademarks in a specific situation, but that doesn't necessarily mean that there will be studies that cover all the various circumstances which arise in trademark cases. And I've also suggested that were a purely numerical approach to be adopted, as it's supposedly the case in passing off, the results would be not dissimilar to that already obtaining in trademark cases which use the average consumer. Most evidence which is introduced would be to issues of distinctiveness rather than the extent of customer confusion. Evidence relating to actual customer confusion would generally be found wanting and excluded, and the eventual decision as to whether there had been passing off would most frequently be made by a judge putting himself or herself into the place of the typical consumer for the goods or services in question. Indeed, it seems to me it's very difficult to imagine a legal system for either passing off or trademark infringement where claimants were obliged to present evidence of actual confusion to prove either. It just wouldn't work. So, and finally, the final point I'm going to make is that there's a strong argument that if we do jettison the average consumer test, it would considerably complicate the adjudication of registered trademark disputes in Europe, which is, of course, a multinational, multilingual jurisdiction. And for that, I just have one quick example. There's a couple, but this one is a very recent case, Intrapress and OHM, which was a dispute between Balloon d'Or, which had a registration for a whole range of goods, and then Golden Balls came along and wanted to register that trademark for many of the same goods. And of course, we all know that Balloon d'Or means golden ball. And so Intrapress, who owned Balloon d'Or, said, we object. Golden Ball sought to have Balloon d'Or, well, no. So anyway, so they said, we object. The General Court then had to have a look at it, and they came to a conclusion that was upheld by the Court of Justice. The General Court said that the signs were only weakly conceptually similar, and at most, and there would be no confusion. It held that the average consumer, including the average Francophone consumer, who would generally have a weak understanding of the English language, would not see the marks as meaning the same thing. Furthermore, the clear difference between the origins of the two words were differences which were likely to make the immediate discovery of the hidden meaning, i.e. golden balls and golden balls, the immediate discovery of the hidden meaning of the sign more difficult, both for the Francophone consumer and the Anglophone consumer, with an average level of attention. Finally, the General Court held that in any event, it appeared improbable that a translation and comparison of these two marks would spontaneously enter the head of the average consumer concerned, contemplating a simple purchase of everyday consumer goods. And again, it seems to me interesting to note that the General Board reached these quite complicated consumers about Francophones and Anglophone consumers without taking into account any empirical evidence about, for example, the level of understanding of either of these groups or indeed any other language groups in the EU. So, there are then, it seems to me, very genuine reasons why it's pragmatic to continue to use the average consumer as a legal construct and not to rely either on behavioral economics or on empirical evidence in every case. However, it is, of course, again, important to remember that marketeers who are responsible for many of the trademark which form the subject of legal actions may not take, of course, such a straightforward approach to their creations. And I'm just going to finish with a few more examples. So what's really the big thing at the moment is emotional branding. And here you see how this works. You begin with the functional benefits, the features, the information, what the average consumer might get. You then go on to the product benefits, again, pretty rational. You get on to the consumer rewards, and then you get to the emotional benefit, an emotional feeling that binds the brand and target typically via shared values and beliefs. And in fact, Coke is a really big believer in emotional branding. So look at this. On the left, have you all noticed when you buy Coke now, you get names on the cans? You do? You get your names on the cans, so you can buy one with your name on. So this is emotional branding. But I think it's quite funny because this is supposed to be the latest thing, when in fact the other one on the right is a trademark, is an advert for Coke from 1936, I believe. And that's pretty emotional too, isn't it, really? I think. So it seems to me. So another one talking, another marketeer talking, so the Coke guy, actually the guy responsible for selling Coke, described the process as setting out to humanize the product's iconography in new, more powerful emotional ranges which responded uniquely to a customer's life moments. And I think I just saw this one. I don't know if these guys have decided to go for emotional branding or not, but it seems to me that any company that now uses a cat in their advertisements is probably thinking emotional branding. So that's O2 previously, that's O2 now, telephone. Okay, so clearly then for marketeers, they're not thinking about appealing to any rational consumer with information. Now, it's unlikely that either, it seems to me, European courts or national courts will change their practice to take account of social branding or emotional branding, and I really don't think they should. However, it does not seem impractical to suggest that when assessing both distinctiveness and conflict between marks, they do keep an open mind as to the evidence they're willing to admit, or at least to include insights from behavioral economics. I mean, and I would say they've already opened the door to that, haven't they, by looking at, for example, the average internet user as being different from the average consumer. Practicalities, though, seem to me to suggest that while the ultimate decision as to which party might prevail in a trademark dispute will almost certainly continue to be one for the court, as it has been for many years even before the average consumer was discovered, nonetheless, it seems to me there can be no harm in making that decision as informed as possible.